Hello all, Abhilash here. So this is the first session on the Unit 3, the Sales of Good Act 1930. So let's start with the history. The history says the Sales of Goods Act was enacted in 1930. So this act is borrowed from the English Sales of Good Act 1893. In India, it came into force in July 1, 1930. So that's why this act says as a Sales of Goods Act 1930. Prior to the Act, the law of scale of goods was contained in Chapter 7 of the Indian Contract Act 1872. It extends to whole India except Jammu and Kashmir. So, except of Jammu and Kashmir, this act is applicable in all states of India. The formation of contract of sale. The definition says the Sector 4(1) of the Indian Sales of Goods Act 1930 defines a contract of sales of goods in the following manner. A contract of a sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. So basically, a seller who agrees to transfer a movable property, that is a good, to the buyer as a seller. Essentials of contract of sale. From the above definition, the following essentials of a contract sales may be noted. There must be at least two parties. In the first unit, in the first session, we have learned about the agreements, the contract act. For making any contract, there should be minimum two parties. Transfer or a agreement to transfer the ownership of goods. There should be an agreement to transfer the ownership of goods. If I'm selling a TV unit to you, right? So I'm selling my TV unit to you, so that means I'm transferring the ownership of the good to you, and that against the good I will take the price. The subject matter of the contract must necessarily be goods. Sales of movable property is not covered under this act. Okay. The Sales of Goods Act 1930 only covered the movable property. Okay, it can be moved from one location to another location. So, immovable properties is not covered under this act. The consideration is the price. Yes, these contracts based on the price. A contract of a sale may be in writing or by words. It can be in both format. All other essentials of a valid contract must be present. The definition of goods under this act. The goods means every kind of movable property and includes stock, shares, growing crops, grass, things attached to or forming part of the land, which are agreed to be served before sale and under the contract of sale. So actionable claims, money are not included in the definition of goods. Thus, goods include every kind of movable property other than actionable claim or money. Example, goodwill, copyright, trademark, patents, water, gas, and electricity are all our goods may be the subject matter of a contract of sale. The test is if the property on the shifting situation does not lose its character. The said property shall be movable and fall within the definition of goods. Types of goods, we have three types of goods: existing goods, future goods, and contingent goods. So what is the meaning of existing goods? The goods which are physically in existence and which are in seller's ownership and the possession. At the time of entering the contract of sales are called existing goods, where sellers is the owner and he has the general property in them. So existing goods. Let me give the example. If I have electronic showroom and I want to sell I have a TV to sell you. Okay, so I have the existing goods in my showroom, right? So if I'm selling the TV to you, that comes under the existing goods seller contract. Future goods, goods to be manufactured, produced, or acquired by other sellers after the making the contract of sale are called a future goods, as per section 2(6). These goods may be either not in the existence or may or be in existence but not yet acquired by the seller. Let me give the best example for understanding the future goods. Right now, from this COVID-19, what's happening? You have seen that the automakers has faced huge losses. Why? They were having a huge production, and suddenly COVID-19 breakdown happened everywhere. So in India there was COVID, there was a lockdown almost for 1 year. So there was not even a single sale of the cars. Okay. So right now, if you want to buy or purchase a car, so before purchasing car you have to put the order. Okay, you had to give at least 5,000 or 10,000 or something around 20,000 rupees to book your car. So first, what will happen? The company or the showroom will take your order. Once you pay some money for booking your car, right? So they will take your order and they will start to manufacture. Okay, so that comes under the future goods, right? So goods to be manufactured or produced, right? Example, agrees to sell to be all the milk that his cow may yield during the coming year. This is the contract of sales of future goods. Right now, like if you want to buy a Maruti Swift car, then you have to go visit the Maruti showroom. They will take your advance order. With the order, you have to pay some price, and they will give the time period like within the 3 month or 6 month. We will give the your car. So within that period of time, they will manufacture and produce your car. Contingent goods. The through a type of future goods, these are the goods the acquisition of which by the seller depends upon a contingency, which may or may not happen as per section 6(2). Example, agrees to sell a bee a specific rare painting provided he is able to purchase it from its parents owner. This is a contract of a sales of contingent goods. Second example, X agrees to sell to 25 bales of Egyptian cotton, provided the ship which is bringing them reaches the port safely. It is a contract for the sale of contingent goods. If the ship is sunk, the contract becomes void and the seller is not liable. So this comes under the contingent goods. The term contract of sales of goods is the generic term and it included sales and an agreement to sell. Okay, the first is a sale and the second one is an agreement to sell, where the sellers transfer the ownership right to the buyer immediately on making a contract. It is the contract of sale, but where the ownership rights are to pass on some future date upon the fulfillment of a certain condition, then it is called an agreement to sell. Sales and agreement to sell distinguish. Let's understand the difference between the sale and agreement to sell with the example. To sell, it is a contract where the ownership in goods is transferred by the seller to the buyer immediately at the conclusion contract. Thus, strictly speaking, our sales takes which place when there is a transfer of property in goods from the seller to the buyer. A sale is an executed contract. It can be written or verbal. It must be noted here that the payment of price is immaterial to the transfer of property is good. Okay, with example, so a sales his Yamaha bicycle to B for rupees 10,000. It is a sale since the ownership of the motorcycle has been transferred from the A to B, right? A is selling Yamaha motor bicycle to the B with the 10,000 rupees price. That means he is transferring his ownership of bike to the B. Agreement to sell, it is a contract of a sale where the transfer of property in good is a take place at a future date or subject to some condition thereafter to be fulfilled. Okay, sales, in the sales we understand that in the sales immediately the person is transferring his ownership of goods to the next person. Okay, but the agreement to sell, that means it comes with the future contract, future goods. Okay, let's understand this concept with the example. A agreed to buy from B a certain quantity of nitrate of soda. The ship carrying the nitrate of soda was yet to arrive. So this is the agreement to sell. So in this case, the ownership of a nitrate of soda is to be transferred to A on the arrival of the ship containing the specific goods, that is the nitrate of soda, right? So here we can apply same example of Maruti Suzuki, where if you want to buy, if you go for the buy car, first you have to make the agreement to sell. They will give the receipt, how much amount you have paid, which vehicle you have booked, which type of vehicle, with the specifications, with the insurance, with the RTO price, everything they will mention in that receipt. So that's called as an agreement to sell with the future goods. That goods you will receive in the future date. On the 1st March 1988, A agreed to sell his car to B for rupees 80,000. It was agreed between themselves that the ownership of the car will be transferred to B on the 31st March 1998. When the car is got registered in B's name, it is that agreement to sell, and it will become a sale on the 31st March when the car is registered in the name of B, right? So when you have booked the car, you have booked the Maruti Suzuki car on the date of 1st August. Okay. And the Maruti Suzuki showroom promise you to give the delivery of the car on the 15th August. So once they give the delivery of the Maruti Suzuki car to you on the 15th August, the agreement of sale, it's considered as a sale. Why? Because the showroom has transferred the ownership of the car to the you. The other points of distinction between sales and agreement to sales are here. Difference between, you can see, ownership passes to the buyer, ownership remains with the seller till the time he transfer his ownership to the next person. Sales, it is executed contract, and agreement to sell is a executory contract. It had to execute, that's why it is a executory contract. Sale is a risk of loss falls on the buyer, and in agreement to sell, risk of loss falls on the seller. Seller cannot be resell the good. Seller can sell goods to third party as well, right? If somebody gives 20,000 rupees for buying the Maruti Suzuki car, and you just give the 5,000, the seller can sell your car to the other. It can be in case of existing and specific goods. Agreement to sell, it can be in case of future and uncertain goods. In case of a breach of a contract, seller can sue for the contract of goods. In case of breach of a contract, seller can sue only for damages, not for the price. The seller is only entitled to the rateable dividend of the price due if the buyer becomes insolvent. In agreement to sell, the seller may refuse to sell the goods to buyer as per the payment if the buyer becomes insolvent. So this is all about the Sales of Good Act, the concept, definitions, and the difference between the sales and the agreement to sell. Thank you. Best wishes.